Awesome. Good morning, KW the Lakes. Thank you so much for coming to meet my personal estate plan attorney, Mr. Eric. And he's he said I'm the only person that named my my estate the Chevy Cheek Crew. He was like, I haven't had someone like think that, you know. So I have the Chevy Cheek Crew living trust. So yeah, see, you think you've seen it all in 45 years, and then you meet me. And I thought my kids would like that when I pass away, you know. All right, so I'm gonna give you Mr. Eric's bio. Mr. Eric has been a licensed to practice law for 45 years. He grew up in the Midwest and began his career as a CPA before attending Duke Law School, where he served as an editor of the Duke Law Journal. Following graduation from Duke, Eric practiced for 12 years with a Milwaukee-based law firm. He was managing partner of the firm's Green Bay office for 3 years. In 1985, Eric moved to California to become general counsel of Salem Media Group. During his 15 years at Salem, he executed over 100 radio stations, published and digital media acquisitions. In 1999, he managed the company's initial public offering. Since 2000, Eric has served in a number of diverse roles in academia and business. He has been executive in residence and adjacent professor of law at Pepperdine University's Sevier College at Pepperdine Law School. Wow, professor from Pepperdine, that's amazing. His business positions have included president of Salem Media Group and chief executive officer of Media Arts Group, and he has been a member of the board of directors of 5 public companies. Since 2010, Eric's law practice has been concentrated in the areas of estate planning, trust administration, and business law. He loves to serve his clients and is fortunate to enjoy a growing clientele of individuals and business in Southern California. Let's give him a warm round of applause. I'm here to have you here, and I want you to know that I spoke to Eric about my personal estate plan, and I just have not ever felt so comfortable. You guys, he actually served all of California. He's like us, you know, like we're not. When we sell houses, will you take a listing in Victorville or San Diego or LA? Yes, right? So he's the same way. He drove, he actually came last night, spent the night in town in a hotel, so he wouldn't be late today. And he drove over 3 hours to be here with us. So please learn from him, and most importantly, put every single one of your clients in front of him. No, you should never sell a house without leaving them with an estate plan. Okay? Awesome, we've been waiting for you. It's an honor to have you here. Thank you. Good morning.
The best salesperson I've ever been.
I'm all right.
Thank you so much. Thank you, Sophie. It really is a pleasure to be here. You mentioned the Chevy Cheek Crew Trust. It is unusual, but I did tell her that I had another one 2 years ago. I had a client say to me, I want to call my trust a galaxy far, far away. I call it that for. And he said, because when my kids get older and they ask for money, I just say, I can't get it. It's in a galaxy far, far away. So I've had a couple, like usually it's the Susan Smith Living Trust or something, but not that, so they get a little bit different. Anyway, I'm real pleased to spend a few minutes with you today live, and also those of you listening on Zoom. I really am happy to be here for a lot of reasons, but I like the fact that this is a team that uses 3 words, right? Care, serve, give.
Yeah.
Right? I like that. Particularly like the word serve in the middle, because as Sophie mentioned, I've been a lawyer for 46 years now. And I learned early in my career that there's always going to be somebody smarter than me, always. But nobody's going to outserve me. And so the way I think if I've had any success in my career, it's because I can control service, and I'm going to outserve everybody. So 46 years as a lawyer, done a lot of things. Why am I still working? I'm about to turn 73 in April. I tried to retire a couple times. didn't work well. One of the things I learned very early on is that my wife did not want me in the house. For 30 years or whatever, I was out. I was never home. And she got used to her space. And when I started being at home, she said, "Why don't you go back to work and get out of my space?" But also, if you feel good, I feel called to work. I mean, work is noble. And there's nothing wrong with being retired, but I'm not sure I know what I would do with myself if I was retired. I love to play golf, and I played a lot of golf, but it doesn't fulfill me. Work fulfills me because I've got something I think that I can offer to people. And 10 years ago, while most of my career has been in the business side, merger and acquisition work, representing companies in large transactions, and I still do a fair amount of that, and I love doing transaction work, buying and selling companies, those types of things, but I gravitated to estate planning about 10 years ago for two reasons. One reason is no lawyers, just client and me, and frankly, I'm kind of tired of lawyers at this stage of my life, and I really would prefer not to have to deal with them very much. Sometimes you have to, but estate planning is you and the client. Nobody in between. And goodness, it's a great way to serve people. Right? Helping people prepare. Lifetime preparation for disability, what happens if I become disabled? What happens when I die? How do I make sure things are in order for those that are left behind? A very noble goal to have and a very nice way to serve. So, what's the state? Okay. Estate planning is a process, right? It's not a one-time event. And you can see the various check marks. Why do we do estate planning? We want to provide for your loved ones, not just a death situation. What happens if you're not able to provide for them during your life? Is the mic good? We okay on the mic?
Oh, yeah.
Okay, very good. You want to leave behind your assets to the people you want to leave them behind you, and how you want to leave those assets behind. And the other reasons also, and some of them are actually beyond the scope of this presentation, like support the causes you want. Lots of charitable things that people can do with various types of trusts. Don't want to talk about that today. It's really beyond the scope of this presentation. But that's what planning is. And notice that third one, right? We want to minimize taxes and we want to avoid fees. Well, minimizing taxes isn't that big of a deal right now, but avoiding fees is. So what is an estate? We're going to plan for an estate. Well, we have to define some terms. First of all, what is a taxable estate? Am I going to have to, is my estate going to have to pay money to the government when I die? Well, the good news is right now, and that there is a very large exemption from estate tax. Each person has the ability to combination of lifetime gifts and transfers of death of up to $12.1 million. So in a married situation, that's $24 million. Most people don't fall into that category. 99+% people don't fall into that category. 90+% of my clients don't fall into that category. So you really don't have to worry right now about estate tax. That's a federal tax. Okay. There is no state, there is no California estate tax, there's no California inheritance tax. So assets under that number, they all pass outside of the tax. But keep in mind that that $12 million exemption, which is adjusted for inflation every year, goes away to the tune of 50% of it in 4 years. And the reason for that is that there was, when the tax bill was passed in 2017, it made that estate exemption very, very high. In order to compromise, the president and Congress worked out a deal that it would revert back to what it was in 2011, adjusted for inflation on December 31st. 2026. So now I have a bigger percentage of my clients who have to think about the the possibility of a taxable estate in 4 years. They've got multiple properties. They're growing in value as time goes on. So you have to be aware of that. But again, most people that I come in contact with, that you come in contact with, really don't have a tax issue. And as I said, so far, everything's fine in California. If California passed an estate tax, like some states have, I think that would accelerate the people leaving from the state. There are already a lot of them leaving the state. If all of a sudden they realize they have to pay an estate tax, I think that will go away. So I think we're pretty safe in terms of California not having it. So that's a taxable estate, but what's a probate estate? Probate estate are those assets that pass to the next person or persons, the next generation at death, that have to go through a probate or a court administration process. Now, there are lots of things that pass at death that are not subject to probate. Life insurance passes outside of probate. You probably know that if a client owns a property in joint tenancy, husband and wife has joint tenants. When the first spouse dies, the surviving spouse takes full title to that property by operation of law and doesn't have to pass through the California probate court system. What happens if they die in a common accident? Oops, now where does it go? Okay, so we have to think about those things also. You may see clients that have property that they want to take title as community property, husband and wife as community property. That's good to a certain extent, but it's better if it says community property with right of survivorship. And we'll talk a little bit more about that later in the presentation. Retirement funds. So if you have an IRA or 401k, that passes outside of probate. It passes to the people who are the person or people that you designate on your beneficiary designations. Pay on death accounts. So a lot of times somebody will set up a bank account and they want to make sure that if they die, that account goes automatically to a beneficiary. So they can tell the bank, I want to set up a POD, pay on death provision. So they basically name a beneficiary. And so if I died and I had a POD for my wife, it wasn't a joint account. It would go to her, it would go to her outside of probate. So there are a lot of ways to pass assets outside of probate, but you have to keep in mind that there are a lot of assets that are subject to probate. And one of the chief goals we all have is we don't want to go through the probate court system. It's the last thing you want to accomplish. You may have seen or been exposed to transfer on death deeds. TODs, not a good idea. First of all, you're going to have problems with title. Often title companies are reluctant to be involved with those things. It's not a good way to transfer real estate. The last thing you should keep in mind is that there is an exemption. So assets that are otherwise subject to probate, if they're less than $165,000, can pass through a small estate exemption. So does that mean you can relax and there's never a probate issue? No, you can't, because it doesn't take much to have $165,000 of assets, like in a home, right? What's the value of this home in California? It doesn't take much to have a home, even net of mortgage, that's worth $165,000 or more. So probate's got to be on your mind, and the goal is we don't want to go through probate. Okay. And then the last thing is the trust estate. So the trust estate are those assets that are held within the living trust, the revocable trust that attorneys help set up for clients, or clients may set up for themselves on the internet. I'll talk about that a little bit later also. You hear about wills, right? People have wills. They say, I'm covered, I got a will. Right? And that's all my assets are going to go to my children pursuant to my will. Well, that's fine. At least it designates where the assets are going to go. But a will is subject to probate. Okay, so assets that pass under a will that are probatable assets are going to be subject to probate. Okay, so if you die testate, which means you die with a will, then this is the way it goes. If you die intestate, if you die without a will, then your assets are gonna go under state law. Lengthy statute that says, where do assets go? Okay. If there isn't a will. And somebody will say, okay, well, I'm fine, I'm great, okay, I'm single, I don't have any kids. And you explain to them what will happen if they die without a will, and it will go up to parents. That's the first step if there are surviving parents. And they go, so what do I have to worry about? Well, here's a good example of what you should worry about. I have a client that sold his company in December for a lot of money. And his son, early 30s, had a small piece of the company. So his son got a big check at closing also. The father has been my client for many years, and I did his estate planning many years ago. He now has, as a result of that sale, a potentially taxable estate upon his death. And for every dollar that exceeds that exemption that's available to him, that's additional money, 40 cents on the dollar will go to the government. That's the estate tax. That's exactly what it is. It's robbery. I'll give him my lecture on that another. But think about it. So the son goes, well, I explained to him, you need an estate plan. And he's 32. What do I need an estate plan for? I said, well,
Young people.
yeah, here's why you need an estate plan. So if you die and you don't have, and you're not married, and you don't have any children, you don't have a will or trust, your assets are gonna go up to your parents. Now, how smart is that? He's got about a $2 million estate. $2 million goes up to his parents, and his parents die, and 40% of that $2 million goes to the government. How stupid is that? So you're hearing the message, right? Wills don't solve the problem. A lack of will certainly doesn't solve the problem. You need to keep focusing on what's the best solution for you and for your clients if you have an opportunity to talk to them in terms of lifetime disability planning and death transfer. Okay, so I forgot to put the thing on testate and intestate, but I just explained that briefly to you. There are different kinds of wills out there. I don't want to spend much time on this. The typical thing you see is somebody does a last will and testament, in which they say these are where my assets go. Or if they have minor children, it's the will where they will say, I want the guardians for my children to be so and so. Now, if nothing else, a will is important in that respect, because if you have kids that are minors and you die without a will, some judge is going to decide who raises your children, and I don't think any of us would want that. So at least in that respect, a will helps. Okay. Holographic wills are handwritten wills. In California, they're legal. Okay, they could be subject to dispute, they could be subject to somebody attacking them, but by and large, those are legal. Yes.
Do they have to be notarized?
Holographic will does not have to be notarized.
Like you just read it, send it.
And in California, by the way, a will only needs to be witnessed. It does not need to be notarized. Then there are other wills, out-of-state wills, military wills, which are real simple. You're about to be deployed. Yeah, they want you to have something down, okay, because you never know what's going to happen. Oral wills, forget it. Oral wills are not enforceable. So if you have a will-centered estate plan, that's what you end up with. But if you have a trust-centered estate plan, there's going to be a will. It's going to be part of it. It's going to be called a pour over will, and what that will say, in addition to if their guardians need to be named, it will say that if I die and I own assets that are subject to probate, they should have been in my trust. They're going to be poured over to my trust, where they'll be distributed pursuant to the terms of that trust. So that's why you'll see sometimes the term pour over will. Your basic trust terms, write a trust. It's a contract. Okay, you have somebody who is a settlor, trustor, grantor used to have somebody who was established as a trustee, and then the trust names the beneficiaries who receive the assets upon death of, in a married situation, first spouse, death of surviving spouse. When we create a living trust, it's living in this respect for sure, and that is that it's revocable. Okay, so if you create your own living trust, you can amend it tomorrow, you can amend it next week, you can change it anytime you want to. Okay. Until such time as you cannot because of incompetency or until your death. And it's only at that point in time, certainly at death, where the terms of that trust become irrevocable. They can't be changed anymore. So we have somebody who establishes the trust, we have a trustee. Okay, the trustee has a fiduciary responsibility to act in the best interest of the person establishing the trust and to carry out their wishes. When you set up your trust, you're your own trustee if you're single. If you're married, you and your spouse are going to be co-trustees, and you typically would provide in a married situation that one spouse becomes disabled, the other spouse can act solely upon death of the first spouse. The surviving spouse is in charge of administering the estate of the first spouse to die, but then you have to deal with what happens when the second spouse dies or a common death. Who is a trusted person that will carry out your instructions under the terms of the trust. And the trustee has a lot of powers that kick in, particularly at death, right? And you can see, and I'm not going to go through each of these things, but you'll see the importance of having a trustee who you trust, right? Who will carry out your wishes and ultimately get the assets down to the beneficiaries that you designate. Now I'm going to return back to the first slide. This is the first slide, repeat the first one. Again, it's a process. It's not just I do it now and it's done forever. I may want to change it next year. I may want to change it 2 years later. I may get married. My spouse and I might want it. He or she may have one. I've got one. We might want to join. I'm working on one right now. Where couples getting married in April. They each have one, but they want to do one now that they're going to be married. So it's a process where you see what the goals are. Okay. And again, I emphasize, estate planning is lifetime planning and at death planning both. Right? Think about incapacity, think about death. It's a process. Use it to achieve your goals. The plan just isn't the documents. The documents reflect and memorialize what your plan is. So what are the objectives of the plan? Again, lifetime. What happens during a period of disability? What do we do to make sure that there isn't a fight from the next generation? Very, very important. We want to coordinate tax planning, and it's not just estate tax planning, it's coordinating it with income tax planning, because of the change of big exemption that's available, a lot of planning now is as much income tax planning as it is estate tax planning. Maybe I'll do another seminar on that someday. That's way beyond the scope of this conversation.
You want to learn and grow, so yes.
Yeah. And the other thing you want to do is you want to avoid the risk of a conservatorship or guardianship, not for children. Guardianship is a legal term that can relate to adults also. You don't want to have a situation arise where there has to be a proceeding in court to appoint someone as a conservator of your estate. You deal with that through proper documentation. So those are your lifetime planning objectives, and then your death planning objectives, extremely important. Again, let's avoid probate. Right? Why? Time. Particularly these days, most of the courts are even closed. So much is done through Zoom and other things, even when the courts are out. It's as long as it was 2 years ago to move through a probate process. It's even longer. Easily a year, 2 years to resolve those things. Okay. Privacy. If you're in estate is in probate court, it means that it's either in a will or it's done because you had no will. Well, if it's in probate court with a will, it's public record. So everybody who wants to find out what was in your will can find out. Do you really want that? I mean, maybe your will said that you want to give 25% of your estate to an organization that you love, but somebody else might consider to be controversial, right? What's nobody's business, whether it's controversial or not, and nobody should know. If your estate plan is encompassed in a trust, it's totally right. Nobody knows. The only people who know are your trustee and the heirs, the people who are going to receive your assets. And then cost. I can't emphasize this enough. If your estate is in probate and it's valued at $500,000, wouldn't be that hard, right? Maybe one house, 2 houses, $26,000 of statutory fees that are paid to lawyers and to the people that have been appointed to administer. $26,000 for a $500,000. If it's $1 million estate, $46,000. How hard is it to have $1 million estate? It's not that hard. Got a couple houses, got a Schwab account. Why? And take it to $2 million, $65,000. These are by statute.
Is that like a percentage or is it just?
It's based on the size of the estate, and so it's in the California statutes. If the estate is this size, these are what the fees are, by statute. So the lawyers and the administrator have a right to get those fees. Compare that with setting up a trust. One time, pay a little bit of money to do that, maybe you amend it in a couple of years, and depending on the lawyer that you use, a lot of lawyers don't charge for small amendments. You want to change a trustee, you want to make a, you want to add a cash gift when you die, you know, to a charity. Most lawyers don't charge for that. Even if they do, you can find one that won't charge very, very much. So think about it. The cost savings, the time savings, privacy, right? So those are things that you can do with the trust. Other things you can do with a trust is protect your beneficiaries as long as you want to protect them. You have to think about it. Let's say that you have 2 children, 22 and 18. Okay, and you're married. Well, you want to think about the horrible thought of a common death, right? You're on a plane and you go down. And you've got a $2 million estate when you think about the properties that you have. Do you really want your 22, 18-year-old kid to get a check for $1 million? Most 18-year-olds I know would probably go to Cabo to start.
My
Go to
son,
Europe.
sure.
It's unresponsible. And so what you do is, so you put in the trust provisions that it stays in trust until they reach a certain age, or until they reach certain ages. Maybe they get a third of it when they're 25. They get another half when they're 30. They get the rest of it when they're 35. For larger estates, you might even want to consider a dynasty trust, which means a lifetime trust. If you think about a client that could potentially be transferring $3 million to a child, they might want to set it up so that it stays in trust for that child's lifetime. Child gets all the income, the child gets a right to have principal taken out if they want it for further education, if they develop a health problem, those types of things. But it forces that child to make it on their own, right? To go out and be responsible, but at least they've got that legacy that their parents left them. They're going to get income on a regular basis. And then you give that child maybe a power to appoint that asset to a limited category. Give the child the power to appoint that money that's in trust when they die to their kids, to charity, to their spouse. So there's lots of flexibility that can be done in that respect. And then the other thing that's not on this slide is planning for disabled children, special needs children. Special needs children are typically on some type of government assistance. Well, if they inherit a bunch of money, they're going to lose governmental assistance. So you want to think about structuring some type of special needs, supplemental needs trust within the trust document, it means that that money is available for that child, but in such a way that they don't lose the governmental benefits that are there for them. So there's all kinds of things to think about when you're doing planning objectives for death. So the foundational estate plan, what does it look like? Well, when we're done, it's gonna look something like this, depending on the lawyer and what the cover he or she uses, but here's a whole menu of documents. Right?
That's mine.
This is yours, my friend. This is yours, okay? So it's not just a trust. Right? It's the whole trust and everything that surrounds it, the ancillary documents. So the documents that are in there for lifetime planning are a durable power of attorney and medical directives. That's for lifetime issues, okay? And then the death planning is centered around the trust. Right? When we use the living trust, the at-death planning, if we don't use a trust, is going to be a will, subject to probate, or no will at all, which means there isn't any stupid estate plan, right? You just let it go under California law. Bad result. So yes,
All our wills, subject to probate.
yeah, if you die with a will, and it says, I want my assets to go to my children, and you have $165,000 of assets in your personal name, or more, that's gonna go through the probate system. Bad result. You know, yes,
Even if it's a holographic will,
doesn't matter,
doesn't matter.
that doesn't matter. Because somebody has to oversee distribution of assets. It's either gonna be your trustee in a trust, or it's gonna be a court.
And you can't have it in the will. You can't say on a holographic will, I appoint my daughter to be the.
Oh, that's fine, you can appoint the daughter, and the daughter will then have to take that to court and be admitted as the person to administer the estate under the supervision of the court, with all the expenses
State's gonna get paid.
that go along.
And she was stipulated, no.
Okay,
There's no, like, this should be on your first quarter goals to get this done, like, I'm sorry.
Yeah,
Like,
yeah.
like,
whoa, first quarter, come on, I don't have time. There are other lawyers out there.
Yeah, but yeah, I always want only the best, so you guys know I have Eric.
Sure.
I want you, Mr. Eric.
Okay,
So we want you, Mr. Eric. We want you.
So one of the documents that's in here is a durable power of attorney. And that's a document that says, I appoint so-and-so as my agent in the event I'm unable to make day-to-day household business decisions. Very important that you have a trusted person in that capacity.
Okay, I have a question on that.
Yeah.
Can you appoint someone that's not a family member? Like, could I appoint you or an attorney to remove the emotion?
Absolutely.
Okay.
Absolutely, and often, you don't see a lawyer, particularly a lawyer who's doing the work. So if you said to me, I would say no, because I have an ethical issue. I'm drafting these documents, and I'm not gonna,
Got it.
I don't want any argument that I was having some influence on you. But often, it might be a sibling, for example, who's sharp, who's really smart, and then it keeps the emotion out of children.
Yeah, so, for me, it was just such a big peace of mind to work with Eric on my personal stuff. Just because I'm like, okay, I have health issues, you guys know that, right? But I also have all these businesses and stuff going on. So just having someone with he asked me questions I wasn't thinking about, and I mean, it was just so professional. So I urge you, if he has the time to get on his waiting list, to have him in 2 years as soon as possible. Like he told me, you must really trust Jay Chacon, and I said, I do. She wouldn't think so, but I do. She's like, it's everything. And then I have situations where I was like, I have a tiebreaker, like in certain situations, I was like, then I have my sister, if my kids can decide something. And I said, look, I just want you to put in there, I want a leopard print casket. And I want my, but I said, but my son, if I die in the next 3 years, he's 18, I do absolutely do. He cannot manage $500 rent. Like, there's no way he can manage assets, so I would want his sister to be overseeing that. And then to make sure that, but then he said, where he wants to further his education. I said, well, and we put provision there, like if he has a wedding, I'll let him get a little money. If he gives me grandbabies, we'll have a little extra money.
It's funny, culture change, and one of the reasons I stopped teaching is that my cultural references went over the student's head, right? 'Cause I used to teach a class on constitutional law, kind of a basic class, and when we got to talking about the criminal side of things and the presumption of innocence, those things. Well, I use the OJ trial as a classic example, and use it also to talk about philosophy of the law. What is the law? Does the law come from God? Does the law come from the legislature? Where does the law come from? And there's this thing about American legal realism, which is the law is whatever the jury says it is, right? And so OJ was acquitted because the jury said he was acquitted. Now, I don't want to get into an argument about whether he was guilty or not, but the point is, that was a great example to use in 2000, 2001. We'll get to be 2010, 12. Who's OJ? So the reason I say that is the issue of a wedding, right? I always put in situations where money's going to be held in trust for a period of time to make sure that the younger child is protected. But you want to make sure that Jay isn't stifled, while the younger child is protected. So the younger child or the older child has the option to take advancements. They want to they got a great business model. They want to start a business. They go to the trustee and give them the business plan, and the trustee advances money out of the trust. And of course, I'm old school, right? I've been married 50 years. I always put in a provision about wedding because I have 2 daughters. I paid for 2 very expensive weddings. I know what it costs. But now what I'm finding out is that a lot of young people don't want to spend a lot of money on weddings. They just don't. They want to go to a barn somewhere and have a little party. So it changes, but starting a business is still important. Purchasing of initial residence, hugely important, right? Somebody's got their money tied up in trust for the next 7, 8 years, but they see a great opportunity to buy their first home. Well, let the trust advance the down payment out to them. And then when the trust is finally settled up, everything is evened out, so that both kids end up with the same amount of money. Oh, that's a lot of the fun of working with clients and talking about issues with children and how is one child different from the other. So I got a bit off track, so I'm sorry. So I'll hurry through this, but powers of attorney, that's part of the lifetime document. And that says that you act on my behalf if I can't, because I'm disabled. Different types, general versus limited. I tend to want clients to give general powers of attorney. Whatever power I can give to my agent, I want to give them. Right? Springing versus immediate simply means that, does the power of attorney say that it only comes in effect if there's a disability that's proven by 2 licensed physicians typically? Or is it outright, which it says, I appoint my agent immediately. Now, why would we do that? The reason I talk to clients about that is particularly if it's a long marriage. Okay, a couple's been married for a long period of time and they say, I want my spouse to be my agent if I become disabled and vice versa. And I say to them, okay, if something happens to your spouse, you want to move, right? You want to be able to move quickly. You really want it only effective if you can go find 2 doctors that will certify that your spouse is disabled. Or would you rather make it immediate, stick it in the drawer, and it's there if you need it. It's a matter of trust, isn't it? I mean, it comes down to trust. If most people have been married a long time, say, I don't want to have to make my spouse go through all that stuff of finding 2 doctors. No, just make it immediate, because I trust that my spouse isn't going to try to take advantage of me by pulling it out of the drawer someday and trying to mortgage the house. Well, they can't, they wouldn't be able to do it. So things to think about for clients as they make those decisions. Okay, so that's one of the lifetime documents. The next lifetime document, extremely important, is the advanced healthcare directive. If you don't have one, you should have it. Even if you don't do the rest of the estate planning. A very important document, you appoint an agent to carry out your wishes with respect to healthcare matters that come up. And so lots of questions that you ask the client. So how do you feel about keep me alive no matter what, or don't keep me alive unnecessarily, right? Because we know with technology today, you can keep people alive pretty much forever. Well, does that make sense to use up all the assets of the estate for all those costs? And 99% of my clients say, check the box, that please don't keep me alive unnecessarily, but there's plenty of protection there because technology and medicine evolves constantly. And so we try to keep up with language. What does persistent vegetative state mean? What does irreversible coma mean? And so it's a very, very important document. It deals with issues like, look, I would prefer to remain in my residence at the end. More and more people want to do that because technology, home hospice care, those things really allow that. And most people want to be home, in their last days. Some people say no because I had a bad experience with a parent or whatever, but very important document, which is part of what I do in the comprehensive state plan, right? Just more things to think about that we talk about when we do the healthcare directive, and then hand in hand with the healthcare directive is the HIPAA authorization. So HIPAA is the Health Insurance Portability and Accountability Act, which is a federal statute, but it has a California corollary to it, and that is a statute that deals with privacy of medical information. Extremely important that your medical information be kept private. You don't want your medical problems out there for people to know that, and so doctors are very sensitive to this. But think about appointing your agent under your advanced healthcare directive to help make decisions for your end of life, and then the healthcare agent can't access your medical records to be able to make an informed decision. So what you need is that HIPAA authorization, which you sign that authorizes your healthcare agent to have full access to your medical records. And it's a very important thing that was brought home to me recently because right after Thanksgiving, my wife had a serious attack and was in the hospital. She's fine, but it was a very serious issue. And I go to the hospital and I'm sitting in the room and the doctor comes in and he goes, "Who are you?" I said, "I'm her husband." And she fortunately was talking. And he said, "Well, do I have permission to talk to your husband about you? We've been married for 50 years, okay?" And he's, because he's scared, because he could be held liable if he did not have it. Well, I didn't have our advanced healthcare directive with us in our HIPAA authorization. I could have gone home and got it right. Unfortunately, she said, yeah, you can talk to him. But these are really important documents. Yes.
So on that note, what is like the next of kin? So let's say that somebody isn't, your family members in the hospital, could be a parent or so, and then you call and get information. Happened to one of our coworkers, and I was with her, and with her out with COVID, and then they said, okay, who's next of kin? So how does that play without having the HIPAA authorization?
Well, in a desperate, dire situation, sometimes the doctors will say who's the next of kin to make a decision. But I'm telling you, that's a risk. Because increasingly the medical profession is scared to death of disclosing information. It's not fully authorized. So it's just don't count on, whoever the next of kin is will be able to address the issue. Have the document in place. Okay, and then just a couple of summarizing things. Will versus trust. I'm kind of repeating what I said before. Which is, and by the way, we're happy to provide these slides to anybody.
Awesome, thank you.
There's no copyright.
Okay, awesome. So I can send them out to them after this if
Sure,
you want.
absolutely,
Okay.
absolutely. Okay, so again, the will is death only. The will doesn't plan for incapacity like a trust does. Okay. We have court involvement in most cases, public record, not good stuff. Trust deals with both lifetime disability issues and death issues, sets forth the instructions for incapacity, so it goes hand in hand with the durable power of attorney, right? Assets outside the trust, assets in the trust. And the trust remains private. Okay, so that's just a little bit of summary again. So does the state plan make sense for you all? One person thinks so.
I'm just trying.
Yes, do this.
Doesn't matter if you're unmarried. Remember the example of the son of the wealthy client who doesn't have a plan and $2 million is going to go up to his parents if he dies, which means $800,000 if it goes to the government when his parents die. Makes no sense. Yes.
How often do you update the trust?
Okay, so what I do is I tell the client when they sign, you have some responsibility on your own to think about changes in your life, material changes in your life. If you get married, if you're single, you get married, let's talk about changing trust. If there are children, and there are going to be more children, or if there aren't children, there are going to be children, be thinking about that, not necessarily now, but as the time comes. My responsibility typically is to watch what's going on with the law. Okay, so if Congress signed or passed and the president signed a new law tomorrow that said the estate tax exemption is $1 million instead of 12, I'd be letting my clients know we may need to do some more planning so we're not paying the government any money. So it's a combination of, but you want to change the trustee, it's time to amend. You want to change the plan. You know, I was going to give $50,000 to the Red Cross. I don't want to do that anymore. That's in the trust. Those types of things. So, but normally it's not amended very much at all.
So what do you
How
recommend?
about are you gonna go over the tax purpose, the tax implications of the trust? Once you have a trust and then I die, my kids get it, then do they have to pay taxes on behalf of the trust?
Okay, so here's the deal on inheritance.
Inheritance, yeah.
Okay, there is no inheritance tax. Okay, so when your children receive assets from your estate, they receive them with no tax consequence. At least that's the law today. And the other nice thing is that the assets are stepped up in value to their date of death value. So if you have a house that you bought for 200,000 and you die and it's worth $1 million, it's valued at $1 million in your estate. Well, if there's a $12 million exemption, what do you care? Still no estate tax, right? But when your heirs get it, they get it at $1 million income tax basis. So if they turn around and sell it, they have no tax.
So it's good, now it's, we turn around and sell it, but now once they sell it, it's worth 1.5 million. So even though it was worth, at the time of death, it was worth $1 million, but now it's worth 1.5, we wanna go back and sell it, will they get taxed on that?
They would get taxed on the difference between the date of death value and the sale. What I'm saying though is if they sell it relatively soon after the death, the tax would be minimal.
Minimum?
There wouldn't be that much time for it to appreciate in value. But in general, the answer is don't be worried about taxes for your heirs because there is no tax on inheritance of that in California. There's no inheritance tax.
Besides real estate, if it increases in value basically from the time.
Yeah, but isn't that a nice problem? Yeah.
So I build everything like this based on what you're talking about here in California. I take off and say, okay, forget about California. I'm gonna go to Timbuktu,
Yeah.
Tahiti, whatever, live. Is everything gonna stay self like living in California?
Okay, so the answer in general is if you move out of state, you typically are gonna you're not gonna leave assets behind in California.
Well, if I got children, and let's just say my children stay, and I just say, okay, I want to get out of California. I'll go to Texas, I'll go to Tahiti, right?
Okay, so if you have a trust and you move to Texas, you go to a lawyer in Texas, show the lawyer the trust and say, does this work in Texas? Most states will honor trusts that are drafted in other states, but you need to check. Spend a couple $100 to have a lawyer look at it, say, yeah, this works fine. Arizona, it's not a problem, I know. Nevada, it's not a problem. But you need to make sure that your documents comply with state law. So for example, if you have minor children for some reason, you might leave them behind with a guardian or an accident or whatever. The provisions about guardianship, if they're in a will, you want to make sure that the will is proper under the laws of the state in which you live. But by and large, Trusts are portable. They move with you. So again, does it make sense? Yes, it makes sense. I don't care if you're unmarried. You need to be thinking about it, because if you've got a house, for example, think about that $165,000 of probatable assets. Otherwise, if I have that or more, my heirs are in probate court. And who do you want to get that house if you die? Set it up, set up a trust, and then do these other documents also, the power of attorney, the healthcare things, and you get it done one time. And then to answer your question about how often, it depends on circumstances as they move along. But most trust amendments are not expensive. Obviously, if you have children with special needs, you want to think about planning for that. If it's a blended family, right? One person bringing some assets, one other person bringing other assets into the marriage. You want to make sure that the children of the one spouse ultimately get the assets that spouse brought to the marriage. That's part of the whole trust planning process. So then, can I afford it? Get this guy and say, he's wearing a jacket, it's probably really expensive. Well, the answer you need to ask, the thing you need to ask, can I afford it? Can my heirs afford probate costs? $46,000 being taken out of my $1 million inheritance. And I have to do that because my folks didn't spend a couple grand to set up a trust. And maybe more importantly than the money is, do I want the state of California to decide who gets my assets? No, you need to decide who gets your assets. Yes.
How important is it, just so that everybody, I have a transaction now, and that's why questions I learned the hard way myself. I Googled a lot about my client, he's very young, but in this scenario is, how expensive is it if I afford it, where they had the mom, they're living trust, mom was sick, mom passed away, but they did a living trust on their own. Through a legal system, through the internet, did it on their own.
Yeah.
But it wasn't done correctly.
Yeah.
So now they wanted to sell the house right away back then, and then they couldn't because the trust, even though it was stipulated in the trust, now I had to Google it myself as an agent because it didn't help them.
Look at the last bullet point.
There you go. The hedge
So
fund.
why don't I just use one of these wonderful internets? The internet offers everything.
They had to go back to court and wait another year.
You can go to Rocket Lawyer, you can go to LegalZoom, Robert Shapiro, he was an OJ lawyer, right? Robert Shapiro did all these ads about LegalZoom, you don't need a lawyer. And besides, if you have a real tough question, you get lawyers backing this up. No, go online and fill out your trust. We the People, it's another organization. I call them trust bills. And it's not like I'm worried about the competition. I mean, that really is not the issue. Here's the problem with these internet services. They don't ask all the right questions. They don't ask the detailed level of questions that I asked Sophia to be able to get to the core of what she wanted for her plan. And the other thing that these services don't do is they don't follow through with the funding. Because if you have a trust, but there's nothing in it, it's worthless.
You have to go back and have a judge decide what was right or what was wrong.
I have a client who his estate, he and his wife have an estate that's worth close to $20 million. He's one of my, I don't have any of those, but he's got a big estate, 6 pieces of real estate. He did a trust back in 2002. He came to me last year, new client. And he said, I said, okay, so you have a trust? He goes, yeah. So he hands me this trust that funded in 2002. And I said, great, so you funded it? He goes, what do you mean? I said, well, what's in it? Well, nothing, but I do have the trust. So he's got 6 pieces of real estate in his name or his wife's name. If he died with nothing funded in his trust, then it's in probate, right? And with a $20 million stake, you're probably talking $400,000 or $500,000 of probate. Wow. Not to mention the hassle of figuring out where the asset is supposed to be. Okay, so I strongly advise against using the internet. So you can use it, and sometimes It may work if it's real simple and, yeah, but why not do it right?
Yeah, I'm about saving money, they know that, but this is not a place to
Yeah.
spend money,
And so,
please, don't go to
Yeah.
circus.
the key is, yeah.
You recommend putting life insurance policies in a trust or keeping it separate?
No, you can't. Okay, so life insurance, you cannot transfer ownership of a policy to a trust. It has bad tax consequences. The way you deal with life insurance is through the beneficiary designation. Okay, so what I often tell clients, if they got $1 million insurance policy out there, is, and they probably have named their spouse as the beneficiary, and then maybe the kids as the backup beneficiary. That's okay. But what happens if the two of you go down in a plane crash and the spouse is out of the picture, and now that $1 million goes to the kids, and they both, one's 18, one's 19. We're back to the problem of a lot of money being in the hands of people who don't know how to handle it. So why not make the trust the beneficiary of the policy, and that way the money goes to the trust where it's distributed pursuant to the terms of the trust, and the trust may say that upon the death of the surviving spouse, which would be one of the two when they go down
Someone
the
told me
plane.
it wasn't a good idea to do that $1 million into the trust, because they said now it increases the 12 million. It,
No, it's counted in it's counted in 12 million no matter what.
right.
Okay, but $1 million is only 1/12 to 12 million, and so it's gonna be,
So it depends
it's gonna
on,
be in the estate for purposes of taxing it, regardless of how the beneficiary is designated. But there's nothing to worry about unless you're getting close to that $12 million.
so you recommend that it go into the trust?
My recommendation is that you talk with your lawyer about, does it make sense to make the trust the beneficiary? Because if you want that cash to be distributed pursuant the same way that the trust is set up, then why not have the money go right into the trust? And the trust may say that upon the death of the surviving spouse, the assets of the estate go into trust for the benefit of the two children until such time as they're 25 or 30 years old. That way the money stays in trust and it doesn't get dispersed out. Yes.
So what you're saying is your life insurance, your beneficiary, put the beneficiary trust name, so you have to build a trust first, right?
Yeah. Yeah, you gotta get that trust in
Like, you
place.
have to build a trust first, okay, so no matter, okay, I get it.
And again, I'm not saying that it's bad necessarily that they name the spouse, because what are the odds of a common act? But this is what lawyers do, right? What's the worst case scenario? What's more likely is that the first spouse dies and the money goes to the surviving spouse. And they're both happy about that. Okay. But then I use the example with clients, and I have to use a different casino because we're down here. I use Chumash, which is up here where I live, okay, but what's a close?
Pachanga.
Pachanga, okay, so the couple goes to Pachanga and they hit $1 million jackpot. And they open a bank account and put that money in the bank account, and they open it in their own personal name, okay? They don't open it in the name of the trust. And then they get, and they do that when they're at Pachanga, because they got the ability to set up an account. And on the drive home, they're killed in a car accident. Where does that money go that's in that bank account? Well, it's not in the trust, so it's subject to probate. That's not a good example. So, yes,
I have a question. What if the husband has a 401k?
Yeah.
Doesn't appoint the wife as a beneficiary, appoint someone else outside of the
Yeah.
immediate family? Can the wife like that?
okay, so 401ks are interesting because the default in a 401k is that it's going to go to the spouse. Okay, that's, if you don't specify it, it goes to the spouse. You can designate that it goes somewhere else. I don't want to get into a discussion of what rights the surviving spouse might have to allege that something should have gone to him or her as opposed to the surviving spouse. But again, retirement plans, you don't put those in the trust, you deal with them through the beneficiary designation. Yes.
I have a question. If you have properties in Mexico, how would that work here? Because
That's a good question.
I have a home in Mexico. How would that happen if the legal rights of the United States are the same as Mexico rights?
Okay, I don't know.
Okay.
One of the things I've learned after 46 years as a lawyer is to know what I don't know. And I don't know. So Mexico probably has their own laws about where,
Yeah, they're very
Real-
strict,
that
like
much
super
that much I
strict.
know.
Or like it was like a big
Yeah.
issue with like.
And so I'm not
residents.
confident the answer to that. If that becomes an issue, we need to find an attorney that deals more with international
Okay,
estate planning
Okay.
issues.
thank you.
Okay, quick question.
Yeah.
So you have your estate plan, you have your personal home, but then you own an escrow that owns other properties. How do you combine and bind into a pension fund?
You transfer title of the stock of the escort to the trust. Basically, or if it's an LLC. Okay, so the idea is that if the real estate is owned by another entity other than you transfer ownership of the entity, not of the real estate, into the trust. Okay,
So that's the trust on this.
right. One of the documents that Sophie, I don't think she would mind me saying.
No, go for it.
One of the things she's signing today, after we're done, is an assignment of her ownership interests in the various LLCs or corporations that she has an interest in. There's real estate underlying, and we don't assign that because that's owned by that particular entity. So,
Yeah, I have
I know
someone
we've
who's-
gone an hour, I'm sorry. We
No,
don't.
no, no, we're good.
Okay.
So, yeah, for me, as you guys know, like, I feel comfortable with Eric because it's complicated. Like, I have a percentage of this corporation, a percentage of that, and I have like different things, and I was like, if I pass away, like, I've been really waiting for today because like, if something happens, I'm like, oh my God, my kids are gonna be, they don't even know what I have. They're over, it's not even me put in a place now, have peace of mind. You know, you have peace
Yeah.
of mind that everything I've worked hard since, like, for 30 years, it's my kids will get it.
It's, it's all here, right? And so I'll probably make an electronic copy if she wants one, and she can give a copy to Jay, she can give a copy to whoever she wants to, but it'll all be here, all these documents.
One last question.
Yes.
I know in the other class that we had, regards to temporary one exchange. So the kids, okay, I'm gonna say an example, like myself, let's say I wanna leave my boys something, or my husband's very particular, like, I worked all my life from them. But when they decide to get married, they don't want it to be the girls, they want it to be just for them. How do we go about that? Because if they get married, isn't it common law, whatever?
Yes,
No.
we get it.
Okay, so here's what happens, when-
I asked this too.
so you and your spouse have an asset, and there's a death and it goes down to children. Okay, under California law, that inheritance is separate property. It's theirs, their sole and separate property. That's true whether they're married at the time or whether they later get married.
But I think they mentioned though, if they commingle back, we can.
Exactly, so the
Okay.
only way that becomes community property is if that person who inherited it chose to put it into a joint bank account, chose to take actions which showed that it was part of the community, and then if there was a subsequent divorce, the other spouse would be entitled to have it. And so the lesson for the children is
No, it's like a community separate.
understand that you have
Keep it
rights to
separate.
separate accounts.
It's Hispanic thing.
Because I hear,
It's not just Hispanic, they're raised.
I hear it nearly every day, my son's gonna get married. My son's gonna get married, I'm not so sure about her. I really don't know about him, what's gonna happen, it's theirs. But they need to be educated how to keep it.
Oh, I'm a future monster-in-law for sure, so I like, hell no, no one's taking, no one's married my son to the state, you know? Yeah.
All right, so-
Any other questions?
Oh, yeah, so we're, do you guys have any other questions for Mr. Eric?
I got a couple slides.
Oh, yes, go ahead. Okay,
And
yes,
this, hopefully this is what you're going to find, thanks, this is great, I'll think about it, but what about my clients? Right? How can I add some value for my clients by learning a little bit about this? Okay, well, look for an opportunity to talk to your clients as they're buying a house. How are you gonna take title? Pretty important question. And so if it's let's say it's a couple, fairly young, this is their first home. They're gonna go, I don't know, I think my dad told me, just take it to joint tenancy, that way if one of us dies, the other gets it. Okay, but what if they both die, what if you both die at the same time? So discussions about taking title, even if you're representing a seller, hey, how do you hold title in this property, you're gonna buy another one, so how do you intend to take title in the new property? Know the basics of how title is taken. I think in your real estate training, you may learn a little bit, about this in terms of getting your license, but, so what's wrong with joint tenancy? Well, I just said, nothing, unless they both go, or what happens when the first spouse dies and the second owns it outright and he or she never does anything about it, and then they die later on. Not a good solution. Right? What about tenancy in common? Well, that means that you each own an undivided, let's say 50% interest with someone else. Husband and wife can do that. Spouses can do that. But if there isn't more, it means that each spouse can convey of their 50% interest to anyone they want to when they die, under their will or under their trust. So then you look at another option, which would be owning the property in as community property with the right of survivorship, which is the best solution if it's not in the trust, because then the other spouse does inherit it upon the death of the first spouse. But again, after that, you have the question of should it be in a trust or should it not be in a trust?
I have a question. Could
So-
it be like a general trust? Let's say I want to put my sister, Sophia, as a trustee of my trust. Can she make the decision if I don't update the trust? Say I create a trust now, by the time I pass away next year, I didn't update the trust. Can she take full as a trustee? Can she make decisions on my children and everything, even though it wasn't stipulated that way? Could it be a general?
Okay, so it depends on the powers that you give your trustee. Typically, you're the creator of the trust and you want to say exactly how things are supposed to go. Okay. If you die with those things in place there, she doesn't have the authority to change that.
And just so you know, I made over 50 decisions when I talked. Like, what are this scenario, that's like, it's very detailed, it's very thorough. So nothing is left up to chance or imagination, like, everything is covered in that trust.
Yeah, so I'm just, when I think about you with a client, okay, and what do you recommend? I just think it's a matter of raising these issues with them, having some basic understanding, and then, I mean, this is value added to the client. And as a part of closing this sale with a client, if it's nothing more than saying, if you don't have a trust, I really recommend that you look into establishing trust because it's going to save a lot of potential problems. And you just kind of leave it at that.
One of the questions, do you also help with getting the trust identification number? Do you do that as well?
I'm sorry, take your mask off for just a second.
No, it's fine. Do you help with getting the trust identification number? Do you, this is one of the bullet points that you have to for your clients?
Okay, so here's the good news about a living trust. There is no EIN. The EIN of the living trust is your social security number. Or if it's a married couple, it's either of the socials of the spouses. Because if you have a home in the trust and the home generates income, okay, there's no separate reporting of that. That just goes on your 1040 because it's your social security number. If you put it in an LLC, then it's creating an EIN for the LLC or an S corporation, no excess status. But the trust, the living trust, does not get a separate employer identification.
What if the person passes away and is now?
The survivor gets all, if the trust says the survivor gets the assets of the deceased spouse, the survivor just continues on and uses theirs.
Mother to children. Parents to their children.
Well, the trust will end if it's an outright distribution to the children. The children will then own it. The children will then own it either in a trust they create or they're going to own it outright. But the trust ends when the assets are distributed. Okay?
We'll provide.
Okay, so, I just think helping close the sale is educating them if they don't. Someone will say, oh yeah, we got a trust, we're good. Okay, fine, but many of them probably won't.
What percentage of people have a trust in the country, do you know?
Well, in California, which is what I really focus on, I think it's probably a third of the people. I mean, people just don't, they're not necessarily educated.
It's a good opportunity to call your past clients and have conversations around this.
Actually, I'm sorry, I know she had a question. Go ahead.
Do you produce AB trusts?
Sure.
Okay, great.
So,
What is that?
so AB trusts are another way of saying that when the plan of disposition upon the death of the spouse, for example, is that the assets of the deceased spouse, and think about a couple that's everything's community property, which means that 50% in value of all their assets has to go somewhere when their first spouse dies. It can go outright to the survivor. And that might be okay, except then the survivor can change 100% of the terms of the trust and write the kids out of the will or whatever, okay? Or it can go into trust for the benefit of the survivor. 50% still remains owned outright by the survivor. 50% goes into trust for the benefit of the survivor, so he or she gets all the income from those assets for the remainder of his or her life. And they can take principal if they want to, or if they need to for health, for further education, to maintain a certain standard of living. But they can't go buy a Lamborghini and fly to Cabo on that money because that money ultimately belongs to the kids.
It's very.
So that's kind of the A/B, right? There's two trusts. There's a survivor's trust, there's a marital
Because it
trust.
happens when, let's say the wife passes away, the husband, my brother actually changed the trust and got all the property. Because we didn't know about the AB
Well,
trust.
then he defrauded, that's.
No,
you can't do that.
he legally got my dad to change the trust. He did it completely, did a whole new trust legally. So what my mom's wishes were divided by the kids. But his one brother changed, so he just went to an attorney, did a whole.
Well, you can always change the trust with respect to what's yours. 50% that's yours if your spouse dies.
But they didn't have an AB trust. They only.
Well, then
had-
if they didn't have an AB trust, everything went out right to him.
Correct,
He can change 100% of it.
correct.
Absolutely, that's
So
what's
that's why it's
wrong.
important to know about the AB trust, because
Yeah.
we had known.
This is part of the education for the client, okay? And that is because some clients hear this, particularly long marriages. They hear this lecture from me and they go, thanks, appreciate it. No, I trust my spouse. And I will tell you personally. Well, okay, I've been married 50 years, and I will tell you that our estate plan now says that the survivor gets it out. And I'm not worried about my wife messing with my kids, okay? And she's not worried about it.
You must have good kids.
Well, I think I do, but particularly for younger couples, second marriages, you want to strongly advise that estate of the first spouse to die goes into trust. To benefit the survivor, that's what couples want. I want my spouse to be taken care of for the rest of his or her life. But I don't want that spouse to go to Cabo and buy a Lamborghini, because that money belongs to ultimately.
The new younger wife will get.
I fall in love with the tennis, I use the tennis pro example, you fall in love with the tennis pro. And just, other simple issues for you to think about through the client. What happens if you've got a client and you're in the middle of a transaction and they die?
That's what I was.
Or they
That's
become,
how-
or they become incapacitated, okay? Well, you have the risk of a loss of authority to be able to close the deal. I'm dealing with this right now with an elderly couple that selling their house in Burbank because they want to get out of LA County and they're moving to Ventura County, but they're both in the hospital because of health issues, and LA County has still been in lockdown. They can't get in to sign powers of attorney, those types of things. So this is why, again, advanced planning. So the best solution is have this property in a living trust, because then you have a trustee successor who can step in and close the deal. At least have a durable power of attorney so that the agent and the durable power of attorney can step in and close the deal. At worst, gotta go petition a court to approve the deal, buy transaction, right? I mean, who's gonna, what buyer or seller is gonna sit around for 5 months waiting for a court? They're gone. They're gone. So just simple things for your clients to think about. Okay, I couldn't answer the question about real estate in another country, but real estate in another state, it should be titled in the name of the trust if you find as a trust, because otherwise, when that client dies, that property that's owned by the individually in Massachusetts, they have to be subject to probate in Massachusetts, whatever the Massachusetts.
So the name of your trust has to be on the title of your property.
Yeah, so Sophia's is Sophia Chacon, trustee of the Chubby Cheap Group. Yeah, and you have to find a lawyer in Texas to, to do that, because I'm not licensed in Texas, I can't do that. But easy, there's a network of lawyers all over the country. Okay, last couple things. Use of LLCs, you've probably heard about, it, or S corporations, using another entity to hold real estate. Okay. For your house? No. Okay. Lots of potential problems putting your house into an LLC. Loss of potential due on sale with a lender. Okay. Insurance issues. Now your insurance agent might consider you a tenant of your home, so they're going to raise your insurance rates. Potential of losing a capital gains exclusion. Right now, there's a $250,000 exemption from capital gains if you sell your home. If you have a single member LLC, you can still keep it, but a lot of times people set up dual ownership LLC, and you're going to lose that. So with respect to a residence, no, do not put it in your trust, but don't put it in an LLC. LLCs work great for investment properties. If you're building a lot of investment properties, you might want to look at creating an LLC to hold that. The beauty of an LLC is it's limited liability. And the idea is that your personal assets are shielded by this LLC entity. So if a tenant slips and falls and the insurance doesn't cover their injuries, they can only sue the LLC and get what's in the LLC. They can't get what else you want outside. But don't just automatically say we need to form an LLC, because there are compliance costs. California has an $800 a year franchise fee just for the privilege of having an LLC. And you might be able to deal with it just by having the right amount of insurance. Buy a big umbrella policy. And if you're going to have tenants, screen your tenants carefully. Right? Make sure that they're not people that are, smoking dope and creating problems and doing that type of thing. And so you minimize your risk that way. So my point is, LLCs, yes, we're thinking about. But
They sue people for it. Yeah, I've seen that. Some people like 5 or 6 times. That's a red flag.
yeah, exactly.
The
So,
professional plaintiffs.
Yeah, the point of these, again, I put it in all caps underlined bold. Talk to a lawyer if you're thinking about doing it. And I don't mean because you have a real estate lawyer, terrific lawyer. Okay, close.
Yeah, he looked up John Hansford, he said it's legit. You have a good lawyer here.
You do. And so it's not just, oh, this is Eric's trying to find more business. No, but you should get legal advice before you start looking at forming LLCs. You have another entity, it's another tax return that has to be done. The income and the expenses slow down to you personally, but the LLC still has to prepare the tax. So there's compliance costs. Okay. We're just about that, I'm sorry. Summary. Goes back to slide 1, right? What do you want? I want to control my stuff when I'm alive and when I can still control it. I want to take care of myself and those I love when they become disabled. I want to give what I have, I worked so hard to get, to the people I want to give it to. And I want to give it to them the way I want to give it to them, outright in trust, delay. And I want to do this while saving every dollar I can. Tax dollars, not so much of an issue because of the big exemption. Probate costs, attorney's fees, yeah, that's an issue. So if that's what you want, if that's what your clients want, then what you should do is maintain a comprehensive estate plan. And I'll just leave you with a personal note. Last word, right? I really am impressed with this organization that you put together. And to me, it's all about using your caring, using your serving to add value for your clients. Right? Just 3 simple quotes. First 2 are, I don't attribute them to anyone, but hey, add value every day. Sharpen your skills and your understanding. My philosophy of life is I want to be smarter tomorrow than I was today. That goes up to the day that I die. And if your presence doesn't add any value to me, then your absence.
Oh, okay.
This is what I do over here. And then the last one, this guy was pretty smart, right? Thanks.
Yes. I'm saying that to all my ex-husbands and boyfriends there.
Albert Einstein says, don't try to be a success. Right? Try to be value. If you're a value, you're going to be it. success. And thank you so much for.
Oh, yeah. Let's give him a round of applause.
Trust, is that a percentage of how much the trust is in totality or how? what is it?
Funding the trust?
Yes.
That just simply means the mechanical process of moving assets into the trust. Filing deeds.
So we're moving all my deeds, my properties to my trust.
So the cost associated will be pretty small. Okay, so the cost of moving your residence to the trust will be just the standard recording fee, $25, $30 for it, right? Any property that's not residential, anytime you transfer that, there's an SB2 fee, that's $75. Okay, so she'll have to pay 75 plus the normal recording fee for the other property. Not a big deal. And then the other thing that you do is you look at your personal bank accounts. If you keep large balances in your bank accounts, you should go to your bank and tell the bank, I've created a trust, I want to transfer title to my account, to my trust. There's a little document that you'll send. That's what.
So all my bank accounts will go to the trust too, but. I have so much peace of mind, yes.
How long is the wait?
My wait list?
Yes.
Well, I'm about to hire somebody. And by the way, does this help? He's bilingual.
Yes.
Seriously, I mean, I feel like such a disadvantage because, I mean, Ventura County, I mean, I think there's a lot of business.
You live
I
in
mean,
the.
you have to be a US citizen, right? I'm not gonna represent somebody who's not a US citizen because it's too complicated for me. But I'm hoping to hire this young man after he passes the bar, which he will. He's a first-time bar passer, but I am so busy. It's hard to say. But if I took on something today, it's probably 6 weeks out before
Do it.
I could do it. But I can't start until you give me the information, right? You had to fill out a whole. I
But I was on it, right? I was on it. I was
Yeah, what a surprise.
there.
I have a 13-page questionnaire. When somebody retains me, I give them, I say, here's who you go home.
Within 24 hours, I had it all done.
Wow.
I don't.
So it's timeline from the date that I get that information back. And then we need a conversation. We've done it by phone. It's doable by phone. I'm an old guy. I like the personal touch. This was hard, but I want to be here when she signs. Right?
See, he's still, I love that. For those of you that were not here in the beginning, I want you to understand the caliber of human being and professional that Mr. Eric Halvorson, I hope I said that correctly. Halvorson.
Norwegian.
Really, yeah. He's been practicing law for 46 years. He grew up in the Midwest, began his career as a CPA before settling in Duke Law School, where he served as an editor of Duke Law Journal. Following graduation from Duke, he practiced for 12 years at a Milwaukee-based law firm. He was managing partner in the firm's Green Bay office for 3 years. In 1985, Eric moved to California to become general counsel of Salem Media Group. During his 15 years at Salem, he executed over 100 radio, station, publishing, and digital media acquisitions. In 1989, he managed his company's initial public offering. Since 2000, Eric has served in a number of diverse roles in academia and business. He has been executive in residence and adjacent professor of law at Pepperdine University's Severn College and Professional Law School, Pepperdine Law School. His business positions have included president of Salem Media Group and chief executive officer of Media Arts Group, and has been a member of the board of directors of 5 public companies. Since 2010, Eric's law practice has been concentrated in areas of estate planning, trust administration, and business law. He loves to serve his clients and is fortunate to enjoy growing clientele of individuals, businesses in Southern California. I mean, like, you guys, this is the best of the best. He's the Gary Keller of his industry, and we bring the best to you. So get on his wait list, fill out the paperwork. You have to pay him up front because then he's not gonna work on you. So pay him up. He's extremely affordable. When he told me how much he charged me, I was like, oh, I thought it was like a deposit. Like, he's very affordable. Please, get on his list. Maybe we could do something where we all can hire him at the same time. You guys can hire him and then he can come out here and sign. I know for a fact I'm hiring him for my parents, my brother, my sister, and Reina. Like, we have 4 family members that are gonna hire him, and so it'll be worth his trip to come back and do all 4 at the same time. So maybe you guys can come to that list, okay? So let's give him a KW the Lakes round of applause.
Is providing,
Come on, Scott.
so.
Get your food first.
No, come on, Scott.
Okay, you're gonna be show the cake
first. Before everyone disperses.
Scott, come on. You guys, Scott is our preferred woman inspector.
Oh, I didn't.
Yeah.
I'll have these.
Scott's amazing. He's
Where's
been.
my introduction? I've never done it.
He's a CrossFit champion that has been here one man. Okay. Yes, Scott's amazing. He can do push-ups with one hand and still do it. Yeah, Scott's amazing. He's been a blessing, a support to Kid of the Lakes from day one. When we call him, he's always willing to sponsor you guys. So he sponsored some brunch for you guys today. Please support his business. Give him an opportunity when you represent a buyer for a home inspection. How many of you have used him before? Yeah, right. Look around. You guys use Scott. He's amazing. The clients love him. The lady clients love him. It's all good. Thank you.
I won't take up too much of your time. You have way better information than I did. I'm gonna go home and handcuff my spouse. And have a conversation with my kids. Like I said, I'm not gonna take up too much of your time. Guys, I'm Scott. I run Coast to Coast Home Inspection. I've been doing inspections in California now for 7 years. I have my personal experience. I've been doing home inspections for 26 years. So there's obviously a lot of inspectors out there now, and everybody and their brother seems to be getting certified to do home inspections because it's pretty lucrative business, or it was. I know that you guys, you listing agents, we're having a conversation with you. I know a lot of you don't think about doing listing inspections, and I have no idea why, especially in the state of California where everybody is so happy. Everybody wants to wait until that thing goes into escrow and then you do a home inspection. Get ahead of your home inspection, get ahead of the process. Start doing listing inspections, okay? I'm not going to harp on it. I'm not going to tell you guys what to do, but trust me, do a couple of them and you will see the benefit. It costs the same as a normal home inspection. We do the same exact thing, but you get ahead of the process. The other thing is when you guys are doing a disclosure report, you can hand that report, that inspection report with your disclosures. Everything is right there. Now, if the buyer chooses to do a home inspection, okay, fine, no big deal. They're just going to pay that extra fee to do the inspection themselves. But by you doing it, you give your seller peace of mind that, hey, I put my home on the market and I really don't have anything to worry about. Now, in California, it's an as-is sale, right? And that's reason why a lot of you guys don't do listing inspections. It's an as-is sale. I don't care. I got a house on the market. This guy's ready to move to Texas or Utah or wherever he's moving to, Georgia, Tennessee. They just want to get out from underneath. They don't want to do any repairs, nothing like that. Okay, that's fine. But to me, I've been doing this a long time. So I always, and I grew up in the Midwest, so I question people's ethics all the time and morals, especially now that I live in California. I think I've done it since day one, but that's just me. So when I do a home inspection and as I'm doing this inspection on this house, and I'm thinking to myself, why didn't these people fix this? Why didn't these people fix that? Why didn't these people fix this? Why didn't they get ahead of this? Why didn't they just do this? You know, and in the home inspection process, when we're doing this inspection for the buyers, it's comedic for us. I mean, go on Instagram, look up any home inspector. They're posting the most comedic stuff because we find the funniest crap, but we find the most frustrating stuff too. And that frustrating stuff can get handled in the listing process. I have probably, I would say 50 agents right now that I do listing inspections for. And none of them have to do a home inspection. Maybe every once in a while, they'll do a home inspection. But the seller always has the same quote. Well, this is an as-is sale, so we're not gonna fix anything. Now, these agents that use me for their listing inspections have been doing these long enough that they have their rebuttals. And usually there's a handful of really important things that get improved or repaired prior to the close of escrow. And the seller feels a lot better about their decision on fixing these things. They have a little bit more peace of mind. Maybe their heart's a little bit more full. I don't know how important that is to people, but in their mind, they feel like they've done something right. Okay. How many times I do a home inspection on a flip and nothing is done with the roof? Because the only thing that people look at when they drive by the house is the front of the house, the landscaping. Oh, that's a beautiful home. Let's put an offer on that house. And they get in, brand new floors, brand new cabinets, brand new sinks, all this stuff is brand new. But the home inspector gets there and the roof is the first thing that should have been done. Now, I do inspections for flippers on when they first go into escrow so that they know what they're running into. Now, I don't do this for a lot of them. I have probably 5 flippers that I do this for because they basically want their contractors concentrating on the repairs and the rebuild. So I will go in, I build this list of repairs or list of fixes for them, and they always do some repairs to the roof, which is extremely important. But when they're all done, the houses, they're perfect. I mean, next to perfect. And then I'll go back in, I'll do another inspection for them, I'll follow up just to make sure that electrical plumbing things are good and they're all in working condition. These are all things that you can do in the listing process. Now, you don't necessarily have to sell your clients on doing a listing inspection. It's just an idea, bring it up to them. What do you think about doing a listing inspection? How many times do you guys do a listing presentation, and prior to doing that listing presentation, you're really nervous because that seller has like 50 cats, 20 dogs, the worst carpet in the world, the house smells, and you're thinking to yourself, okay, I know this is an asset sale, but I need to maybe convince these people that they should probably clean this place up a little bit before we put it on the market. Sometimes that's what we're there for, because that inspection report gives them an idea of, oh crap, we really have some work to do. Now, I know it slows down the process, okay? It might slow down the process maybe 2 or 3 weeks because some of these repairs need to be done before you can put that house back on the market. But in the long run, it's probably going to be worth it because that 3 weeks that you've taken to repair those things and get those improvements done isn't on the back end now, it's on the front end. So it really doesn't slow down the process. Okay. And then for you guys that are working with buyers, you know the process. In terms of prices, guys, I get this all the time. I probably get 10 calls a day. I want a quote on a home inspection fee. I always have to laugh because this is probably the most important investment people make, but they want to go with the cheapest home inspector. Okay, I don't agree with that you should go with the cheapest, but I also don't agree that home inspectors should charge a fortune for the home inspection. So we're at the lower end. Our starting base price is $325. I had to raise my prices this year, $25, specifically because the government decided that they were going to start charging for Venmo and Zelle and these other applications. So I get passed on that, and then gas prices are through the roof. Thanks, Biden. But that's good shit. Yeah, so it's still inexpensive. And then I charge $100 for pool inspections. I used to be a pool builder, so when it comes to the pool inspection, I'm very knowledgeable when it comes to that stuff. And then we have our sewer scope coming this weekend, so we will actually start doing sewer scopes starting Monday. So if your buyers or your clients want their sewer scope, we can do up to 100 feet. Not really sure what I'm going to charge. I know that there's a lot of guys out there that are charging a little bit more than they need to. So I think we'll start off at $100 with the inspection, and then $200 or $250, depending on the size of the home, without the home inspection. So, and then I will provide the office with a price sheet for you guys. A lot of you, I have your email addresses. For those of you that I don't, if you feel comfortable, give me a card afterwards. I'll shoot you out a price sheet. I also have some information back over there with some warranties that I actually provide for your buyers. I have 5 guys that work for me, 4 here in California, 1 in Georgia. So if you know somebody buying a house in Georgia, we can handle that. And then we cover all of Southern California. Literally, I was in Chula Vista yesterday, and I'm going to be in Oxnard on Saturday. So we're all over the place. Barstow, the high desert, the low desert, you name it.
Your turnaround time, like say for instance, like I call you, like, hey, I need a home inspection, like ASAP, because I like to do, a pre-list of home inspections. But if we're going on the market, it's gonna go that quick.
Yeah.
They're in the area to sell, but I want to get that done. If I give you a call, like, hey, I know it's Thursday, can we get this thing inspected, tomorrow or Saturday, what's the likelihood of that?
Very likely right now. Once we get into the peak season, I'm usually like 2 or 3 days out, but right now we can accommodate you. Probably a 24-hour turnaround. Like I just had somebody scheduled for tomorrow at 3:30. So, but like I said, I have 4 guys that work for me, so we can typically handle you pretty fast. And then we do same day reporting. So you'll get the report either later that evening or before the start of work day the next day. So we don't do on-site reporting. We try not to be at the property for any longer than we have to. Our average inspection time is probably 1.5 to 2 hours. And we show up a half hour early. So that half hour that we show up early is included in that time. And the reason why we try to show up a half hour early is because we don't want to be late. I don't know if you guys hate it when you're late, we hate it when you're late. So,
You entertain buyers, I know I've had buyers that like, hey, can we be there for the home inspection?
Oh, yeah.
Inspectors,
Yeah.
so ask you questions.
Yeah, for sure. Crazy thing is people say that all the time. Oh, we're here to follow you. Okay, perfect. And about 5 minutes later, they're off. Because we're taking so many pictures and looking at stuff that it's like, how are we doing? This guy's doing. So eventually they'll go off and grab their tape measure and start measuring. They'll do other stuff. But yeah, we don't mind at all. I mean, I've had people crawl in the attics with me, guys going to crawl spaces. So yeah. And then I have a construction background. And I love when people say, oh, this guy has a construction background. Oh, this guy's an engineer. This guy's analytical. I love those people because they have a ton of questions and I always have a ton of answers. And if I don't know the answer, I just make shit up.
You also service multi-unit?
Yes, we do residential, commercial, multi-unit, dog houses, you name it, we do it. Yep, no line. I mean, doghouse has to be pretty big. Yeah, no, we do.
What about the ADUs are becoming popular?
Yeah, they are. The one thing that a lot of people don't know about home inspectors is home inspectors don't call out codes. So when you have something like that, when you have a garage that's been turned into a rental, or you have like this back thing that was added onto the back of the house with a tin roof and shiny electrical.
Yeah.
We don't check for permits. That's your appraiser. Your appraiser is going to check all that stuff. But when we see something like that, we inspect it. We'll inspect the plumbing, we'll inspect the electrical. Unless it's detached, we won't charge you extra for it. So I just did I don't know if you guys know who Tanya Bainbrook is, but I did an inspection for her 2 weekends ago on a 7,000 square foot home. And I get there and the listing agent's like, oh, this is 2 homes. And I remember looking on MLS and I'm like, no, it's one house, but there was a mother-in-law's quarter off the garage. Most home inspectors would have probably charged a full charge or some fee for that extra square footage. I didn't because it was attached. So
you don't charge per square foot?
I do charge per square foot. However, like in this situation of an EDU or a rental unit, if it's not attached to the house, we'll charge extra for it. I usually don't charge. I usually charge like $100 more. I don't charge full pop for it. So
Sometimes some inspectors are like, yeah, the fee is up to 3,000 square feet, and then you start charging over 3,000 square feet.
yeah. So our square footage costs go from, let's say, 500 square feet to 1,500 square feet would be $325. Every 500 square feet after that, add $25. And it just goes up from there. So, and obviously, when you get into larger homes, the price is obviously it's negotiable. I mean, I've done 12,000 square foot homes at my price range, and it works out pretty hefty. So, but usually when you're dealing with somebody that's buying a house that size, they can afford it. So, absolutely, yeah. Any other questions?
I don't expect this moving out of town, so I'm asking.
Thank you. Everybody gets on Panera, let's do it.